Morning everybody, and welcome to what is actually the third update on business interruption.
Your speaker's not working. Please check your connection or use a different speaker.
If you want to just put your mics on mute for the moment, that'd be great.
Working for everything else.
Avoids any background
noise.
All right, I'm going to mute you because you've got background noise on. So yeah, well, this is the third time that we've had an update from One Chancery Lane, and we're delighted to welcome Robbie and Ian to help us with this particular one. Just give you a little bit of background on our two speakers this morning. Robbie has got a lot of experience in defending claims brought against insurers and also in respect of claims relating to possession and commercial property claims, which very often involve a business interruption component. He's also, I've discovered, developed quite a high public profile as an expert commentator, and he's a regular TV news expert, commentating on legal issues. Ian acts exclusively in defendant cases for many of the large insurers within the UK on a wide range of claims, including business interruption insurance. He's acted for many of the major insurance providers, as well as high street companies such as Tesco, Sainsbury's, Virgin Active, Asda, and sporting organisations such as the Premier League and Championship football clubs. He's also advised government departments and world sport governing bodies on claims made against them. And he's actually currently dealing with a major COVID claim against a well-known high street brand, which has raised issues of disability discrimination and breaches of human rights. So that's a very brief potted CV for our two speakers. This event is being recorded, but the primary purpose of that is so that we can produce a write-up for that afterwards. I do appreciate that this is still a sensitive issue in the market, so if there's something you want to say but you don't want it to be minuted or noted, please just preface your comment with that, and obviously that will not then appear in the notes of the event. Okay, I think that's all we need to do. Usual sort of rules about this. It will be Chatham House rules, so any comments that are made, any questions you ask may be repeated, but they won't be attributed to you. Can I suggest you keep your microphones on mute during the talks, but feel free to put any comments you want or questions you want to ask in the chat room. There will be plenty of time for questions afterwards. We're scheduled to finish at 11, no later than 11, but I hope there'll be plenty of opportunity for you to put questions to our two expert speakers. So I think without further ado, I'm going to start with Ian, and the floor is yours, sir.
Thank you very much, Lawrence. Well, good morning, everybody. As you know, the test case went through the court earlier this year regarding business interruption insurance. I'm going to give you some brief facts about the case and the background to it, because that's relevant to what Robbie's going to go on to and the questions that we're going to answer during this talk. And without those basic facts, you probably won't know what we're talking about. So I'm just going to give you some brief sort of introduction of the facts of the case. The case was brought by the Financial Conduct Authority under its market test case scheme. And it brought proceedings on behalf of and for the benefit of many policyholders who were small, medium enterprise businesses. The defendants in this case were 8 leading providers of business interruption insurance, such as Arch, Hiscox, and others. The Supreme Court granted the leapfrog appeal, which was from the High Court. And the Supreme Court took the approach that they would consider a representative sample of standard form business interruption policies, as many of the facts were agreed or seemed to be agreed between the parties. They were considering some 700 type policies over 60 different insurers, which equated to approximately 370,000 policyholders could potentially be affected by the outcome of the litigation. So they took a rough and representative sample of the standard business interruption policies. What did the appeal look at? Well, the appeal looked at the proper interpretation of 4 clauses, and it also looked at a causation element, which I'll touch on in a moment. But the 4 clauses that it looked at initially were the disease clause, the prevention of access clause, the hybrid clause, and the trend clause. Now, I'll go into those in a little bit more detail because you're going to need to know what they mean, because you won't understand what's been decided if you don't know what they are. The disease clause, these clauses in generally provide cover for business interpretation resulting from an occurrence of a notifiable disease, in this case COVID-19, at or within a specified distance of the business premises. So some of the clauses were 25 miles, others were a mile. The prevention of access clause probably does exactly what it says on the tin. This clause in general provides cover for business interruption losses resulting from a public authority intervention which prevents or hinders access to or use of a business premises. A hybrid clause is a clause which combines the 2 elements that I've already set out, i.e. the disease clause and the prevention of access clause. And finally, the trend clause. These are clauses which in general provide for business interruption to be quantified by reference to what the performance of the business would have been had the insured peril not occurred. As I said before, the issue also looked at the issue of causation. And this was specifically in regards to the 4th clause, so in regards to trend clauses, because it was argued on behalf of the insurance that policyholders would have suffered the same or similar business interruption losses even if the insured peril had not occurred. And they argued the claims must fail because it cannot be said that these losses were caused by the insured peril because of how trend clauses require the loss to be quantified. So let's look at perhaps the timeline for one moment. The regulations that came into force on the 21st of March 2020 was the Health Protection Coronavirus Business Closure England Regulations 2020, known as the 21st of March Regulations. And as of that date, this required the closure of businesses, which was set out in a schedule to the regulations. Part 1 of that schedule comprised of restaurants, cafe, bars, etc. And they had to cease to carry on business of selling food on premises. They could only sell for consumption off the premises. Regulation 2.4 required businesses listed in Part 2 of the schedule also to close. These included cinemas, theatres, nightclubs, etc., bars, gyms, and indoor leisure activities. And Regulation 3 of the 21st of March regulations made contravention of Regulation 2 without a reasonable excuse a criminal offence. 2 days later, the government issued various guidance. So there's a difference between the guidance and regulations, as I'm sure many of you know, as to the closure of businesses and to working from home. It also gave guidance on stopping of all social events. I make no puns here and no jokes are intended, including wedding, baptisms, other sermons and funerals. So those social events all had to cease, of course, unless you were working from 10 Downing Street. The government advice concerning business closures included advice that it will be an offence to operate in contravention of the 21st of March regulations. And the business in breach of those regulations would be subjected to prohibition notices and potentially unlimited fines. Further regulations were made 3 days later on the 26th of March, which revoked most of the 21st of March regulations, but imposed more extensive restrictions where Regulation 4 required businesses listed previously to close, and these included nail bars, beauty salons, etc. Regulation 6 then made further restrictions, and this introduced a prohibition against people leaving the place where they were living. So basically you couldn't leave home without a reasonable excuse. And Regulation 9 made that breach of that regulation again a summary criminal offence. So you can see from the restrictions that were in place that businesses were going to suffer, completely obvious. On the 4th of July 2020, the 26th of March regulations were replaced with more limited restrictions. The government then categorised businesses. I'm not going to go through those categories, just safe to say that there were 7 categories of business that the government made on a schedule. Now, the 8 insurance parties to the framework agreed between themselves with the FCA and the Hiscox Action Group, which was an intervener in the appeal. They agreed and permitted the proceedings to be joined, and 21 lead policies should be considered by the courts, which was spread over 8 insurer defendants. And this took place in the High Court between the 20th and 30th of July of 2020. And that judgment was handed down on the 15th of September and run to some 580 paragraphs. I'm not going to go through those, you'll be glad to hear. And on the 2nd of October, the court gave permission for all parties to appeal by way of the leapfrog procedure straight to the High Court, straight to the Supreme Court, therefore bypassing the Court of Appeal. And that appeal was heard over 4 days between the 16th and 19th of November 2020. What were the issues on appeal? At the trial at the High Court, the FCA was substantially successful in the claim. In the main appeal for the insurers, all the insurers, apart from 2, and it's interesting to note that the ecclesiastical company and the Zurich company did not appeal any of the decisions from the court below. In addition, the FCA appealed on 4 issues which they did not succeed at trial. But Zurich was a respondent in one of the FCA appeals. And those appeals concerned the interpretation of the policy. We've been asked a number of questions. What were the main points decided in the test case? Well, simply put, it was basically an interpretation on the policies and the clauses that I've already set out. So the disease clause, the prevention of access clause, the hybrid, and the trend clause. When we ask what the main points were decided, normally we go into perhaps a long spiel about the law and what each judge decided. But in this case, I can say it was very, very simple. What was decided was that each clause should be given its proper and ordinary interpretation. And one of the things that the court constantly said throughout the judgment was that words need to be given their ordinary meaning. For example, the court set out that a person should be able to understand a document and it should not be addressed by a pedantic lawyer who will subject to the entire policy wording to a minutiae textual analysis. It is the ordinary policy holder who, on entering into the contract, is taken to have read through the policy conscientiously in order to understand what cover they were getting. And what the court kept asking itself was, can the man in the street understand this policy? Or if he can't, what should he understand by the wording that's used? I'll give you an example. One of the arguments that was raised by Hiscox, for example, was in regards to the word interruption. The court below found that the word interruption and interference meant the same thing. Hiscox disagreed with that and said that interruption was completely different from interference. Well, if you said to a man in the street, what's the difference between interruption and interference? He'd probably say there is no difference. And that's exactly the approach that the Supreme Court took. they rejected that argument and they said we are applying the ordinary wording, and any interruption can encompass an interference or disruption. So again, all the way through this judgment, the court looked at what was the ordinary meaning of the language and what did it apply. It then went on to look at causation in regards to trend clauses. And in that case, the argument was that the but-for test should apply. Well, to say that the but-for test got its butt kicked is an understatement, because all the way through this judgment, particularly in regards to causation, the court did not like that argument one little bit. The argument that was raised, and I'll give you the paragraph in case you wish to read it. It's at paragraph 168, and I'll read it out to you because it makes quite good reading from a lawyer's point of view. It says this, if I can turn to it. The starting point for the inquiry is to identify, by interpreting the policy and considering the evidence, whether a peril covered by the policy had any causal involvement in the loss, and if so, whether a peril excluded or accepted from the scope of the cover also had any in such involvement. The question whether the occurrence of such a peril was in either case the proximate or efficient cause of a loss involves making a judgment as to whether it made the loss inevitable. If not, which could seldom, if ever, be said in all conceivable circumstances, then in the ordinary course of events. For this purpose, human actions are not generally regarded as negative in causal connection, provided at least for the actions taken are not wholly unreasonable or erratic. So what it said was, and what the argument by Hiscox was that, well, if you had one case of COVID-19 and our premises wasn't within the radius of that one case, then the clause doesn't apply because the business would otherwise not have closed. And the court said, no, we don't take that approach. This is a contribution approach where one case inside might not close a business, but the fact that there were many, many cases outside that exclusion zone or outside the radius of the policy contributed to the government bringing in restrictions which did have an effect on the business. And during the argument, the court used the flood and fire test, they called it, which was to look at teaspoons of water would not cause a flood, but if lots and lots of people may put teaspoons of water into an area, it would cause a flood. Now, which teaspoon was causal of causing the flood? Well, you could say none of them were, but contributing together, they all caused the flood. The same could be said of a single match being lit in a forest. It wouldn't cause a fire. But if lots and lots of millions of matches were lit in a forest at the same time, which match caused the fire? Well, you could say none of them, but the court said, well, if they all contributed to fire, they would all be liable. The but-for test, of course, says but for that one match, there would be no fire. So no one would be liable, which would cause an incredible unfair result. And that's the approach the court took, a contributory approach. When they looked also at inability to use in some of the policies with the restrictions imposed, the inability to use a premises does not, unless the policy specifically meant the whole premises and it was worded as such, did not include the whole premises. So they gave an example of a bookshop, which 80% of its trade was people who were walking off the street. 20% of its trade was telephone and online orders. because of the closures and by the restrictions that the government had put in place, 80% of that bookshop business would disappear because no one was entering the bookshop, no one was going shopping, no one was allowed to leave their home. But 20% of it could carry on because people would be ringing from home, ordering books, and they could be, of course, sent out in the post. And Hiscox argued, well, that was an inability to use the premises because they could use the premises and therefore the clause didn't kick in. And the court said, no, inability to use the premises, unless the clause specifically says it's part of the premises or the whole of the premises, that's therefore included. So the FCA won on that point. In regards to the restrictions imposed as well, Hiscox's argument was, well, yes, there are restrictions, but those restrictions have to be mandatory and have the force of law behind them. The FCA stated, well, that was unrealistic, both in a common sense approach and also a commercial approach. And the court held that there was a difference between restrictions and guidance, but the government guidance, despite not being mandatory, meant that nobody could go out. It was only when it was enforced via the criminal sanctions within the restrictions that kicked in. So the court said even government guidance could be read as being a restriction imposed on an individual and or a business, and therefore the clause applied. So what was the main points of decided in the court? Well, it's right to say that Hiscox particularly got a bit of a kicking, unfortunately, and that was simply because of the wording of their policies. All the policies, the court decided, needed to be much, much tighter in their approach. So those are the main points that come out of the test case. I'll let Robbie move on to the next question. Robbie?
Muted myself. Certainly, yes, absolutely. Well, if you don't mind, I'm just going to share my slides. I'm going to be looking at the FCO's current position following the test case, beg your pardon, the Financial Ombudsman Service, FOS, and I'm also going to be looking at case law that has developed since the test case and is going to be developing in the near future. So, excuse me a moment whilst I share my screen. Hope Ian will tell me if that's not working. Hopefully you've got a slideshow from me.
Yep.
Great. Okay. So getting straight into the meat of the question, what is the Financial Ombudsman's current position? Or the position largely remains that set out in a newsletter from the Ombudsman, which is entitled Ombudsman News 163. It's from July of last year. A Google search for Ombudsman News 163 will take you straight to that article. And in summary, the results of the test case are not particularly surprising. The Ombudsman describes seeing an uptick in complaints relating to how insurance and how brokers of insurance have handled claims for business interruption as a result of COVID-19. In almost all of those cases, what's complained about is denial of cover. The insured says is improper and the insurer says is proper. There is a small residual number of complaints dealt with by the Financial Ombudsman. It doesn't involve that topic. It does involve the selling of the insurance, allegations that it was missold so as to cover COVID interruption in circumstances where it didn't, for example. Delay in considering the claim. One can probably understand that given the volume of these claims that's likely to happen, but something to be aware of, or the amount offered in settlement. There is a case on that actually, which we'll come to later on during the course of this presentation. So keep an eye on that. That I think is possibly going to be a bit of growth area in the future. What reasons were given for rejecting cover? Well, the short answer is that quite a lot of them, as the Ombudsman reports, are consistent broadly with the test case. So it does still leave a few stones unturned. Number one, fairly obviously, there's no business interruption term in the policy. Well, if there isn't a business interruption policy in place, too bad, effectively, from the insured's point of view. The policy provides cover only for interruption caused by one of a list of specified diseases, and COVID-19 wasn't on that list. That's a big area, and we'll see a number of examples of that as we go through, although there is certain wording that needs to be watched out for, because COVID-19 can be caught in circumstances where it's not obvious that it's going to be caught. But if you do have a policy which has a list of specified diseases, and COVID-19 isn't on that list, that does or can prevent that cover from being provided. The policy provided cover where there was a case, beg your pardon, policy only provided cover where there was a COVID-19 case at the premises and there was insufficient evidence that there had been. Fairly self-explanatory. It's all to do with the wording of the policy. Lastly, the policy provided cover only in the context of a public emergency in the local area. And the COVID-19 pandemic didn't qualify as such because it was national, if not global in nature. That's one, I think, to be treated with caution. There's case law on this. It's Corbyn and AXA. And I'll be coming to that later on today. Now, the Ombudsman then goes on to provide a number of test cases. It gives 3 examples. They're backed up with specific Ombudsman decisions, which are available linked from the newsletter I've referred to. Now, what you need to know to understand some of these cases is that COVID-19 is a notifiable disease under the 1984 Act and the 2010 regulations, and it became such on the 6th of March 2020. Now this is what I was getting at earlier when I said that there were catch-all ways to refer to diseases which could encapsulate COVID-19 even if it's not specified. Under a set of amending regulations on the 6th of March 2020, COVID-19 became a notifiable disease. So if your policy uses the term notifiable disease, it's going to capture business interruption caused by COVID after the 6th of March 2020, which essentially means all business interruption caused by COVID. All right, so simply be aware of that. Watch out for the term notifiable disease in the context of COVID-19. Okay, example 1. One of these first 3 case studies given by the Ombudsman. A repair shop had to close from March 2020 and remain closed throughout the lockdown. The policy provided cover where the interruption to business was caused by an occurrence of disease on the premises. Now, what the repair shop said was that it had initially closed because one of the business's staff members did feel unwell in March 2020. Before the lockdown, COVID-19 was suspected, but there had been no positive test. Notoriously difficult to get a COVID-19 test in the early days of the pandemic. And there was no later evidence of COVID-19 on the premises. So the policy provides for interruption caused by an occurrence of a notifiable disease. Note that on the premises and in no other circumstances. What the Ombudsman found, the policy applied only where there was a COVID-19 case on the premises. There wasn't sufficient evidence rather that the illness in March 2020 was caused by COVID, and there was no later evidence of such infections. COVID-19 notifiable disease, remember that term, but it didn't help the business in this case. The business wasn't required to close as a result of a COVID-19 case on the premises, but COVID-19 cases around the country more generally. So the insurer had in that case applied its policy fairly, and the decision was upheld. Okay. Case study 2. A nail salon had been forced to close as a result of the lockdown restrictions. The policy only provided cover where the business was interrupted by government response to a specified list of illnesses, but COVID-19 was not on that list. So not a notifiable disease or a disease more generally, but a specified list of illnesses which did not include COVID-19. The insured complained that COVID-19 didn't exist at the date of the policy, so it couldn't possibly have been included in the policy. Finding that COVID-19 was not on the list, so cover was not provided. The insurer in that case recognised the unfairness to the business. I beg your pardon, the Ombudsman recognised the unfairness to the business, but considered that it was unable to unilaterally extend the policy in the way that the insured would like. So if you've got a specified list of illnesses, check very carefully to see if it includes COVID-19, because for an older policy, almost certainly it won't. Okay. Example 3, a restaurant had been forced to close by the lockdown restrictions. The policy provided cover where the closure was in response to an occurrence of a notifiable disease, that term again, within 25 miles of the premises. The insurer held that the closure had not been caused by a case of COVID-19 within that radius, but by the pandemic more generally. It's the causation argument run in the test case. Unsurprising, really, that causation argument was firmly rejected by the Supreme Court, FCA and Arch. So that argument failed, and the insurer was required by the Ombudsman to reconsider the claim with a view to granting cover. So fairly self-explanatory. It's hopefully clear why the first 2 cases didn't work and the latter did. The latter, its closure of a type encapsulated by the test case. The first 2, policy simply didn't cover what had happened. All right, so it's fairly legalistic. It's a fairly exact words approach, but that's the position being taken by the Ombudsman. What about updates to the case law? I've mentioned this one before, Corbyn and King. You've got the full citation there, found just earlier this year. In the High Court, there are rumours of an appeal, but at the moment this is the current position. And in summary, although I'll go through this in a lot more detail, it's exactly what Ian and I have both been saying. The exact terms, the specific terms of the policy in question, pretty well determine whether or not cover is going to be provided. And understanding these is a matter for their ordinary construction, as I've put it all there, to put the ordinary and natural meaning on the words, as Ian put it, essentially means the same thing. Okay, background. This is Corbyn and King. It is, so far as I'm aware, the only case yet reported following on from the test case, although there are others in the works, and I'll come to those later on. What happened in Corbyn and King? The claimant companies were a group of companies that had a consolidated insurance policy. They operated a total of 8 restaurants. Each of those 8 restaurants was required to close 3 times during the period of the lockdowns. That's March, September, and November of 2020. Okay. The policy covered business interruption loss, where access to your premises is restricted or hindered arising directly from the actions taken by the police or any other statutory body in response to a danger or disturbance at your premises or within a 1-mile radius of the premises. But also, we will not cover you where access to your premises is restricted or hindered as a result of notifiable diseases as detailed in the murder, suicide, or diseases cover. Now, that separate annex or sub-annex of the policy gave a list of notifiable diseases where cover would not be provided, and COVID-19 wasn't on that list. Cover is the third point you need to bear in mind. Cover was limited to 100% of the sum insured or £250,000, whichever is less. Okay, possibly starting to become clear what some of the issues were. The claimant sought indemnification under this policy of £250,000 each, well, higher than that, but limited to £250,000 each for each of the 8 restaurants for each of the 3 lockdowns. All right. The insurer declined cover, and it argued that the policy didn't apply to the COVID-19 pandemic, in that it was a transient, or in that it was not a transient or locality-specific danger or disturbance of the kind specified in the policy, but a lasting state of national emergency. Well, that's pretty questionable, let's be realistic, in light of the conclusions in FCA and Arch, but they argued it anyway. They argued that the disease exclusion clause applied. Again, fairly dubious, given that COVID-19 isn't on that list. It's the reverse of the usual situation, but nevertheless, they ran that argument. They ran the causation point again. The presence of COVID-19 in the locality did not cause the closures. But more interestingly, they argued that the £250,000 limit was an aggregate total for all 8 restaurants, for all 3, so far as I can see, of the closures. They argued it was one continuous period of business interruption, and that £250,000 limit applied to each of the restaurants, all of the restaurants together. So the issues were whether the policy provided cover, 1, 2, which party was correct in respect of the £250,000 limit, or what exactly was that £250,000 limit. The findings, pretty unsurprising on liability in light of FCA and Arch. A disease such as COVID-19 qualified as a danger, fair enough. There was no qualification by locality, save that it occurred within the 1 mile radius of the premises. So the fact that COVID-19 also occurred outside of that 1 mile radius of the premises was not a reason that the policy didn't apply. The danger didn't need to be local or temporary or transient, save within that 1 mile radius. None of those arguments worked. The court didn't see any force in that. Again, I don't think that's particularly surprising. The disease exclusion clause, remember that provision that we will not cover you if it's on a list, if it's not on a list of notifiable diseases. Although it used the term notifiable diseases, went on to define notifiable diseases by reference to a particular list, and that list didn't include COVID-19. So COVID-19 wasn't on the list, and there's a lot of double negatives there, but broadly, it wasn't a barrier to providing cover. The business causation argument, exactly the same conclusions as in FCA and Arch, not remotely surprising, really. The business interruption was directly caused by the presence of COVID-19 within the radius, as well as in the UK more generally. What about quantum? Well, the claimant's argument of quantum was preferred. An expensive day for the insurer, because although it was not beyond the bounds of possibility that there could be a composite policy with a single limit that applies to all premises and all instances of business interruption of that nature, that would certainly not be the expectation in the context of a composite policy. So you can, with good wording, have a policy that excludes liability or does limit or create a composite limit of that nature, but that's not the typical position. So it needs to be spelled out, it seems to me, applying this case, very, very explicitly, and thought needs to be given as to what is one instance of business interruption and what is multiple instances of business interruption, because the insured was successful on that point also. So I don't know that Corbyn necessarily changes a great deal. I think it probably tells us, for the most part, material that we already knew, or at least reaffirms it, with the possible exception of that aggregate policy point in respect of quantum. As I say, I do think that could well be the next growth area or next controversial area following business interruption and COVID. Now, watch this space. Now, as I say, Corbyn was the only reported determination so far. There are 3 others, I think, at the minute to keep your eyes on. These will almost certainly be reported at some point. Smart Medical Clinics and Chubb. That's the one that's reached the most advanced stage. There's a pending trial on liability, and that considers the extent of restriction of access. Presumably that's in relation to one of the later lockdowns where you could operate under certain conditions. We don't know. We'll find out more about that as it goes along. Whether COVID-19 was a relevant disease, well, that's material that's very well trodden, specified in the policy, and it's used the term notifiable disease in case it is captured. And whether a case at the premises was required, again, that's going to be it's fairly well trodden ground, and it's all to do with the wording of the policy. Okay, Simpsons and Amlin, MS Amlin, apparently it's cover under a motor trade policy rather than business interruption as such. I haven't been able to find out a great deal about it, but it's going to be relevant to those of us in the motor trade industry. And I think actually the most interesting thing from a lawyer's point of view is that there's a dedicated business interruption list in Manchester County Court, Manchester Civil Justice Centre rather, dedicated to COVID-related business interruption, and this one is apparently a trial on that list. So it does imply that there's quite a lot more of these coming. The last one is an area I think is going to be of interest, and I don't, to be perfectly honest, really understand why it hasn't been more of an area of interest so far. It's a claim relating to insurance of interruption to travel services, World Challenge Expeditions rather, and Zurich. I haven't been able to find almost any information about this. I think it's at a fairly early stage, but given the disruption for many months and indeed years caused by COVID-19 to international travel, it must have had a devastating impact on that sector. So I think that is an area to keep your eyes on. I think that's going to be a bit of a growth area in the not too distant future. So bear those in mind. You heard it here first. Look out for those set of cases as and when they're reported. In summary, it's all about the wording. Both the courts and the financial ombudsman are adopting an exact words, but not overly legalistic approach. So it's not a very technical take on the wording, but it is a very natural take on the wording. I think that's the best way of putting it. There is recognition that this creates harsh results for insurers and insured alike in certain circumstances. It can seem rather arbitrary, but it is all to do with the wording of the policy. And I think that the concluding thought that I have is that there remain plenty of potential get-out clauses, particularly if there is a well-drafted policy, and that's both for insured and insurers. So it's something we're all going to need to think about, but that pretty well is the position between FCA and Arch and the present day. To say any questions, just ask yourself or, of course, Ian. So that's it from me.
Thanks, Robert.
Thank you very much.
Moving on to another question that we've been asked. Does the presence of so many different policy wordings mean that there are still unresolved issues out there? Simply put, the answer to that is yes. And as you've seen, Robbie has already highlighted 3 cases that we know that are going through the courts. There are going to be more. There are going to be different cases. As Lawrence said at the beginning, I've currently got a case of disability discrimination in regards to a well-known high street brand because they insisted someone entering their premises wore a mask. So those cases are going to come through the courts as well, particularly in regards to business interruption cases. Many of the cases, I think, can be solved by reference to the Supreme Court case, looking at the 4 clauses, the disease clause, etc. There are lots of unresolved issues, but as Robbie said previously, the way forward is to look at the wording, and I'll just refer you to what paragraph 58 says in the Supreme Court judgment, because again, that is probably relevant, and it said this: in the court's view, a reasonable person would not understand the parties in using the words they did to intend such unreasonable results, and would read the clause as intending to cover the effects of a notifiable disease of which there is an occurrence within a specific radius. So that's one instance where the court is saying, look at the words, they've got to be reasonable, they've got to be understandable by the reasonable person in the street. And only 3 or 4 paragraphs on, the court again said this: the cautionary words of Lord Mustow in the charter reinsurance case are apt. There comes a point at which the court should remind itself that to force upon the words a meaning which they cannot fairly bear is to substitute for the bargain actually made one which the court believes could have been better made. That is a legitimate role for the court. So the court will look at, as I say, the wording. Following on from that, the other question that we've been asked is, what are the bigger picture, wider points that can be learnt from the test case? Well, as Robbie and I have already bashed on about, better and tighter drafting of both inclusionary and exclusionary clauses is a must. As Robbie's highlighted, some of those, and particularly the restaurant case, which didn't include COVID-19. Of course, it couldn't have included it in the schedule because COVID-19 didn't exist when the policy was taken out. So it may well be that those policies have to be looked at and re-altered or altered to include now COVID-19. So the better and tighter drafting of both inclusionary clauses and exclusionary clauses is a must. Robbie, unless you need to say anything more, I don't need to say anything, we can open the floor up to some questions. Lawrence, unless you've got anything you want to add?
Not from my point of view, Robbie or Ian. That's been a fantastic summary of the history and where we are currently, and a quick sort of look forward as to what's coming through the pipeline. I'm by far from an expert in this subject. I probably know less about it than anybody else on the call, although I know a little bit more now than I did at 9:30, so that's been good. Ladies, gentlemen on the call, questions from you? Anybody like to go first?
We'll give you our email addresses. We'll give you our email addresses to Lawrence. If there's any questions that you don't want to ask now, feel free to put it in an email to us and we'll happily answer those questions for you in an email.
Absolutely. I like how that.
Hi, it's John Hinton here. Just one quick thought or discussion for you. You say that there are potential future claims coming along, but hasn't there been, large clarity that these policies are meant to respond, and that the insurers would be unlikely to take too many points as to the broad response of these policies?
Well, I'd have thought so, but they did in Corbyn, and they retook an awful lot of very, very similar points. And there was, in fairness, some commentary in Corbyn that because these policies were so wording specific, the test case might, whilst it's binding in relatively general terms, is quite easy to distinguish in respect of specific policies. And that I suspect is the reason why you're seeing cases coming up from other sectors which presumably have different policies and different sort of situations that they cover. So it might not be quite as settled as it seems. And even if it is, there's still quite a lot of work to be done in respect of quantum. So that's my take on it. I see where you're coming from, but I don't necessarily think it's quite as simple as that.
Thank you.
Thanks, John. Any other questions from the floor? I'm not seeing a flurry of microphones going off mute here, so Okay. All right. Well, look, if there's no other questions that people want to ask directly, sort of face to face, as it were, this morning, as Robbie and Ian have said, you can field questions directly to them. Their addresses are obviously on the One Chancery Lane website. You can send them to me, and I'll put them to them. But if one last chance, gone. I don't think there's any point in holding on at the call for any longer this morning. So it just remains for me to thank you both very, very much for the hard work you put into preparing those talks and for delivering them with precision and articulating very complicated arguments for us. So I'm sure it's very much appreciated by everybody who's on the call and certainly appreciated by me. So watch out for the update that we'll produce. We'll send that to you, Robbie and Ian, first for sign off, so you have editorial control over that. Otherwise, I hope everybody enjoys the rest of your day. See you again soon.
Thanks very much.
Thanks very much.
Thank you.